36, it's a hot topic amongst litigators with a raft of new cases emerging year on year. I'm going to give a really brief overview on what a Part 36 offer is, as well as some top tips. So Part 36 sits as a self-contained code within the civil procedure rules. Offers could be made within the claim itself, including pre-action, as well as during the detailed assessment, cost proceedings and any appeal. Both claimants and defendants can benefit from the Part 36 regime as it provides automatic costs consequences. Now, it's very important to make sure that a Part 36 offer fits within some strict criteria which are set out in the rules. The offer must be in writing, it must make clear that it's made pursuant to Part 36, specify a period of not less than 21 days within which the defendant will be liable for the claimant's costs or vice versa, whether it relates to the whole of the claim, a part or an issue, and if so, which part or issue, and finally, whether or not the offer takes account of any counterclaim. The simplest way to ensure you get your offer right is to use the court form known as N242A, which is readily available on the government website. Now, the advantages to a claimant are greater than a defendant. From a claimant's perspective, if they make an offer during the course of litigation and the matter proceeds to trial, the claimant will receive a number of costs benefits if they receive a judgment which is equal to or more than the value of the offer. If the offer is for money, this is a relatively simple process. However, Part 36 offers can be made in non-monetary claims. The cost benefits include interest up to 10% above the base rate, cost on the indemnity basis, plus interest on those costs, and an additional 10% uplift of the sum awarded, although that figure is capped to £75,000. If a defendant makes an offer which is not beaten at trial, they will benefit from their costs after the relevant 21-day period has expired. For claims issued after the 1st of October 2023 that fall into the fixed costs regime, i.e. not the claims that are not within the multi-track, the Part 36 benefits are different, with a 35% uplift being applied rather than indemnity costs. Now, a caveat to using the court form is to bear in mind that Part 36 offers must be inclusive of interest. So you may wish to ensure that your offer includes a provision for trailing interest, in which case you'll need to make that clear in the court form or set your offer out in a letter. And a few other pointers on the topic. There are no limits on the number of Part 36 offers you can make. Part 36 offers cannot be made less than 21 days before trial without the court's permission. A Part 36 offer remains on the table until it is withdrawn. This is helpful in that it puts pressure on the offeree to settle, but we do recommend that parties keep a log of offers made, particularly if quantum has changed during the course of proceedings, that an offeree may suddenly accept the offer out of the blue to the offeror's detriment. A claim may well appear to have gone away, particularly if it's pre-action, but parties should be mindful of an offeree appearing months or years later and suddenly accepting the offer. Once the offer is withdrawn, you will no longer be able to claim the automatic costs consequences. So I hope that's been a really helpful short overview. There are a number of nuances within the Part 36 regime which can't be covered in a short video. However, should you require any advice or assistance, please do contact Birketts Cost Team and we'd be delighted to assist.